In our last video, we described the difference between the TM, SM, and Circle R symbols. TM, you will recall, stands for trademark, and SM stands for service mark, and we described these symbols as common law trademarks. But what does this mean? No registration is necessary in order to use the TM or SM symbols. You can use them on your products and service offerings immediately. And even if you apply for federal registration of your mark and are denied by the U.S. Patent and Trademark Office, you can continue to use the TM and SM symbols. The simple act of using a mark in commerce creates common law rights in that mark, and use of these symbols puts people on notice that you claim those rights. But what are the rights in a common law mark? Being the first to use a mark in commerce in connection with a particular set of goods and services entitles you to the exclusive use of that mark. So if you open a donut shop in Denver and call it Snowcap Donuts, no one else can use the name Snowcap in connection with the sale of donuts, but only in the geographic area you establish for your business. So with a single donut shop in Denver, your rights may extend only to the Denver area. If you open a couple other shops in Boulder and Colorado Springs, maybe you can claim exclusive use in the entire state of Colorado. But if someone in Stowe, Vermont opens a donut shop and calls it Snowcap Donuts, assuming they had no knowledge of your company in Denver, you would have no valid claim of trademark infringement. By contrast, federal registration of your trademark creates nationwide rights to your mark. So even if someone only has a single shop in Stowe, if the USPTO grants their registration of the Snowcap Donuts mark, they would have the exclusive right to that mark in connection with the sale of donuts throughout the country. But what about your poor little shop in Denver? What if you used the name first? Let's suppose you established your donut shop in Denver in 2005. In 2008 you expanded to Boulder, and in 2010 you opened a third store in Colorado Springs. You've not only been selling your donuts in your own stores, but in 2012 you started packaging some donuts and selling them at local ski resorts, and now you sell them at ski resorts throughout Colorado. Now in 2012, along comes the Vermont Packaged Foods Company. They sell pre-packaged foods to major grocery store chains throughout the country, and they want to expand their product line to a set of pre-packaged donuts that they want to call Snowcap Donuts. They apply for federal registration of the mark, and the USPTO grants their registration in 2013. Federal registration gives them nationwide exclusive rights to the Snowcap name, right? But not so fast. If you can demonstrate that you started using the Snowcap name in Colorado before the Vermont company applied for registration, and that you have acquired common law rights as a result of your use of the mark in your territory, then not only can you continue to use the Snowcap name in your territory, but you may be able to prevent the Vermont company from entering the market within your territory, notwithstanding its otherwise national rights. In fact, based upon your expansion of packaged products to ski resorts throughout the area, you may even be able to extend the geographic reach of your common law rights to ski resorts in the neighboring states if those locations are deemed to be within your zone of natural expansion. So it sounds as though common law rights are pretty powerful, and if you're a small company, maybe you shouldn't bother with federal registration. In truth, it's not that simple. To obtain and enforce common law rights, you must be able to prove actual and continual use within your territory. The courts will look at a variety of factors to determine whether you have acquired common law rights, including widespread distribution of your product, public association with the mark, whether consumers associate the mark with you as the source of the goods, whether the mark has become distinctive, and whether you have exercised control over the quality of the goods and have used the mark in a trademark sense. Moreover, if you are starting your business locally, but may have plans to expand to other markets in the future, your ability to do so may be impeded if someone else files for federal registration of the mark. The bottom line is that common law rights are really rights of last resort. If you want national protection of your trademark, you should contact a trademark attorney and seek federal registration with the U.S. Patent and Trademark Office. Besides nationwide protection, what are the other advantages of federal registration? Registration creates a legal presumption of your ownership of the mark, and your exclusive right to use the mark nationwide on or in connection with the goods and services listed in the registration. Registration gives you the right to sue for infringement in federal courts. Registration gives you the ability to recover attorney's fees, profits, damages, and costs for infringement, including the possibility of receiving treble damages in certain circumstances. Federally registered marks achieve incontestable status after 5 years, which serves to eliminate most arguments that the registrant did not have the exclusive right to utilize the mark. Only federally registered marks may use the circle R symbol in connection with the mark, which may deter potential infringers. Federally registered marks are listed in the U.S. Patent and Trademark Office's online databases, making your mark easier to discover by those doing trademark searches, which helps to prevent the adoption of confusingly similar marks by third parties. You can use U.S. registration as a basis to obtain registration of your mark in foreign countries. And you can record your U.S. registration with the U.S. Customs and Border Protection Service to prevent importation of infringing foreign goods. In our next video, we will discuss the different kinds of trademark registration applications.